Good morning everyone, my name is Ricci Anak Willy, I'm from BML. Today I will presenting on digital transformation, artificial intelligence, machine learning and tech sovereignty in maritime transportation law. Practically, I will focus on how AI alert contract particle atomically under the Rodin rule. So the next slide is introduction. In the introduction, I will to explain about the Rodin rule. The Rodin rule is United Nations Convention on Contract for International Carrier of Goods wholly or partly by sea. Commonly known as the Rodin rule, were adopted in 2008 to modernize and harmonize international maritime transportation law. The convention regulates contract for the international carriers of goods wholly or partly by sea and was designed to replace early regimes such as Visby and Hamburg rules. One of its key objectives is to reflect the reliability of modern door-to-door carrier and electronic commerce. The Rodin rule are particularly important because they recognize electronic transport records and seek to balance technology innovation with legal certainty and commercial predictability. So, at the same time, new technologies such as artificial intelligence, that's AI, and machine learning and transforming shipping contract and communication system throughout digitalization. These technologies provide extraordinary efficiency in time and cost by enabling real-time data integration and automated operation adjustment. However, while AI improves the accuracy and efficiency, it also creates significant challenges for the financial principle of commercial law, particularly legal certainty and contractual predictability. So, for the centuries, bill of lading (BOL) have been used as static documentary evidence of party right and obligation under the contract of carrier. A bill of lading traditionally serves three functions. It acts as a receipt for goods, evidence of the contract of carriers, and a document of title. This document are issued at a fixed point in the time and represents the condition and quantity of goods as received by the carrier. So, in contrast, modern shipping increasingly. So, the next slide is legal framework under Rodin rule. I have four article that I add in on my report. The Article 8, Article 9, and Article 36, and the last one is Article 41. So for the Article 8 is Green Electronic Transport Record, that ERT has the same legal effect as traditional paper document, provided reliable method are used to ensure integrity and authenticity. Its function is to establish functional equivalence between electronic and paper documents, and its advantage lies in promoting paperless trade and digital efficiency. So next article is Article 9. So Article 9 is set up procedural requirement for the use of electronic transport records. It requires reliable method for issuance, transfer, identification, and identification of the holder, and maintenance of exclusive control. The purpose of this article is replicates the legal concept of precision in electronic form. thereby protecting negotiability and documentary integrity. So next article is Article 36. Article 36 explain is defines mandatory contract particularly that must be included in a transport document or ERT. This included the description of goods, quantity, weight, shipper and consignee information, and other relevant contractual detail. It functions to ensure clarity and transparency in contractual document. So the last article for my dislike is Article 41. Article 41 is established that the particularly contained in a transport document or ERT constitute prima facie evidence of the carrier receipt of goods as described. But this prevents safeguard inventory reliability and promotes predictability in dispute resolution. So together, this provision demonstrates that although the Rotterdam Rule modernized maritime law by recognizing electronic communication, they are structured around the principle of documentary stability and legal certainty. So next slide is going to present about static versus dynamic tension. For the static tension is the legal system under Rotterdam is premised on the understanding that transport document are static in nature. Static tension is the legal understanding that the content of transport document are set in stone once they are generated. There is an expectation that the contents of the document are an authoritative record of the contractual particular at the time the document is generated. Even electronic transport record are treated as being the same as paper record in that they are static in nature. So next is dynamic tension. So dynamic tension is the legal system respond to AI system that are dynamic in nature. AI systems are designed to update the data they are processing in real time, such as systems are designed to update the operational particular in response to real-time data. There is a fundamental difference between the legal system understanding that the particular of the contract are set in stone once the transport document is generated. AI systems are designed to update the data they are processing in real time. So the next slide is legal certainty risk. In this slide, I will mention about two articles, that is Article 36 and Article 41. For Article 36 is contract, particularly a particle must be fixed at efficiency. That means AI adapters such as weight changes due to moisture adoption, there will become uncertainty. So, however, the AI-based weather routing may change the visa estimates time of arrival, that ETA, which may be done to improve fuel efficiency and safety. While ETA may not be a primary component of the contract like the port of discharge, it has important implications for the downstream commercial chains and the AI-driven change to such information may create the uncertainty. So next is Article 41. So Article 41 is the inventory reliability threatened if AI alerts particular post insurgency. Example, the BOL states have 1,000 ton grains that the AI will update to 985 ton. This will be disputes the rates. So it's scientifically compromise the legal certainty that the bill of lading represent the amount of the good shipped. So the last point of legal certainty risk is chain of custody and authenticity compromise if AI alerts record without human. So next slide is undermining ERT framework. So this is in this slide I mentioned the Article 9 that integrity and control of ERT. So this means is AI dynamic characteristic directly challenge the integrity of the law due to the dynamics nature of AI system, capability of changing such as writing. So the record without any human involvement. So next point is legal friction hold that the negotiable instruments such as actual paper or electronics is one method for recording a contract and the current conditions that of the existing goods at the time of possessions at a particular point in the time when the carrier accepts delivery from the seller. When an AI system alerts the record without cooperation, the human chain of the custody and control is broken. This is contrary to the purpose of Article 9. So the next slide is core agreement analysis. So in this slide, I will mention about 4 things, that is Article 36, Article 30, Article 21, and AI alerts BOL. So for the Article 36 is that the contract particularly must be authenticates AI update without consent, bypass manual signing. So the next is Article 31. So Article 31 is shipper are strictly liable for inaccuracies they provided, but AI update without consent count as unauthorized carrier side alteration. So Article 30 is rule measure about the shipper are reliable if they provided forward input, carriers are reliable if AI system error causes inaccuracy. So the last one is AI alert BOL, that bill of lading. So if AI cleans a bill despite damage, it may be carrier negligence rather than shipper fault. So overall inventory reliability under Article 41 is compromised when AI alert particular. So the next slide is case study and example. So in my report, there is no direct case study exists under the rule not yet enforced, but IoT-enabled logistic expertise illustrate the risk. Smart contract trackability system, sensor discrepancies such as temperature deviations, they can trigger the incident monitoring potential bill of lading. Finicky. Dispute were the data quality. Threshold determines reliability evaluation. A logistic chain example highlight the centralized IoT codification, various leading to non-compliance claims. Analogous to Article 31, inaccuracy if unconsented updates occurs impairing need for the agree producer to previous transport record finality. So, to conclude is AI modification is binding only in integrity and functional equivalent test certify. So the next point is unauthorized or defective update. This is not binding and it fail inventory standard. So the safeguard needed is number one is technical. So technical is blockchain timestamp and distributed legal. So the next is number two, the legal. So legal is mean human in the loops oversight authentication producer. So the rodent room modernization objectives is number one is door-to-door carrier efficiency. Number two, AI can assist such as real-time IoT data and trackability. So number three is without safeguard, the risk of fraud that can be disputed. With the safeguard, the AI aligns with functional equivalence and legal certainty. So that's all for me. Thank you everyone.